Hey everyone, today's unit that we'll be doing is criminal law. My name is Shazia Khan and we'll be looking at learning outcome 2 today, which is to understand the elements of the different offences against a person. In the last session, we looked at understanding the aims and general principles of criminal law. So we looked at understanding what criminal law was, the nature of criminal law, the different categories of crime within criminal law. We looked at the difference between substantive law and procedural law. We also looked at the difference between law and morality and the importance of that. We looked at the different functions of criminal punishment, rehabilitation, recession, and then we looked at the job of the CPS, the Crown Prosecution Service, and what they do in criminal cases. We also looked at the effects of mental capacity in claims and looked at the issue relating to insanity standards. Now we're going to look at the understanding the elements of different offences against a person. So we'll be covering today is analysing the components of murder, illustrate circumstances giving rise to voluntary and involuntary manslaughter, and assess the nature of non-fatal offences against the person. And we'll be looking at lots of case law, but I'll be referring you to some and I'll go through some cases with you. So 2.1, analyse the components of murder. Before we look into this, I want you to watch a video on the issue regarding murder, and it'll identify some references, but also some case law in regards to it.
Law, the law of murder. The law of murder is set out in common law. The legal definition of murder comes from Sir Edward Coke. Murder is, when a person of sound mind and discretion, unlawfully killeth any reasonable creature in rerum natura, and under the king's peace, with malice aforethought either express or implied. The actus reus of murder thus consists of the unlawful killing of a human being, in the king's peace. The mens rea of murder is malice aforethought, which has been interpreted by the courts as meaning intention to kill, express malice, or intention to cause GBH, implied malice. The actus reus of murder consists of 1. An unlawful killing. 2. Of a human being. 3. In the king's peace. Murder is a result crime, therefore causation must be established. An unlawful killing can be committed by an omission. Please see separate videos for an explanation of causation and omissions in criminal law. Some killings may be classed as lawful. These include state-ordered executions, killing in self-defense, soldiers and police in the course of their duties, and in some circumstances doctors can lawfully kill. Killing in self-defense is lawful where the force used is reasonable in the circumstances. In R.V. Palmer, the use of a gun was held to be excessive force where the defendant was chased by 3 men who threw stones and sticks at him. The court held there was no alternative of manslaughter. Self-defense either succeeds in its entirety or fails. Soldiers and police may kill in the course of their duties but will be liable for murder if they go beyond their duty or use excessive force. In the controversial case of R.V. Clegg, Lee Clegg was a soldier serving in Northern Ireland. He was manning a checkpoint. A car approached at speed and Clegg, believing he was under attack by terrorists, opened fire. He fired 4 shots, 3 as the car approached and 1 as the car was driving off. It was the final shot which was fatal. Consequently, he was liable for murder as he was no longer protecting the area or under attack. Doctors may lawfully kill in limited circumstances. In R.V. Adams, Dr. Bodkin, 1957, it was held that a doctor could lawfully give a sufficient dose of pain relief to kill a patient, provided their intention is to relieve pain and not to kill. A person cannot consent to being killed as demonstrated in the cases of Diane Pretty and Tony Nicholson. Euthanasia is not legal in the UK. However, doctors may lawfully withdraw treatment knowing that it will result in death. For example, it is lawful for doctors to switch off life support. This was established in Airedale Hospital Trustees v. Bland. This case concerned Anthony Bland, who had been left in a coma following the crush at the Hillsborough disaster. In Re A, conjoined twins, the doctors were lawfully able to separate the conjoined twins knowing that it would result in death of the weaker twin. Sir Edward Coke's definition of murder requires the victim to be a reasonable creature in rerum natura, meaning a human being. Disability, no matter how extreme, does not prevent a person being a reasonable creature in rerum natura. In R.V. Ingles, a mother killed her son after he had suffered horrific injuries which left him brain damaged and disfigured. The Lord Chief Justice stated, however, disabled Thomas might have been, a disabled life, even a life lived at the extremes of disability, is not one jot less precious than the life of an able-bodied person. A fetus is not classed as a human being and therefore a person who kills a fetus cannot be charged with murder. In AG Ref. No. 3 of 1994, the defendant could not be liable for murder when he stabbed his pregnant girlfriend. The baby was born alive but later died of the injuries. At the time of the stabbing, the baby was a fetus. According to Rance v. Mid Downs Health Authority, a fetus becomes a human being when it has been fully expelled from its mother and has an independent existence. R.V. Malczarek and Steele established that a person ceases to be a human being when their brainstem ceases to be active even if they are kept alive by artificial means. The requirement of in the King's Peace excludes the killing of alien enemies in the time of war. The mens rea of murder is malice aforethought. This term is misleading in that it suggests some sort of ill will and pre-planning, whereas malice aforethought has been interpreted in the courts as meaning simply intention to kill or intention to cause GBH. In R.V. Vickers, it was held that Section 1 of the Homicide Act, which abolished constructive malice, had not changed the position with regard to implied malice, so intention to cause GBH was sufficient for the mens rea of murder. This point of law was challenged in R.V. Cunningham. The defendant killed another in a pub brawl by repeatedly hitting him with a bar stool. He did not intend to kill and argued that murder should only apply to those who intend to kill. The House of Lords upheld his conviction for murder and declined to overrule R.V. Vickers. The mens rea of murder covers not only direct intent, but also extends to oblique intent. According to R.V. Woolen, the necessary intention exists where death, or serious bodily harm, is a virtual certain consequence of the defendant's actions, and the defendant appreciated that this was the case. In summary, murder is the unlawful killing of a human being in the King's Peace with malice aforethought. It covers intentional killings in the absence of lawful excuse. It also extends to where a person did not intend to kill or even foresee death, but intended to cause really serious harm to another. This video is part of a series of videos on law from W.
So as we can see from that video, it identified the main components of murder. So actus and mens, and then looked at GBH with reference to case law, and also looked at the history around murder. Now we're going to look at the components of murder 2.1. So interpretation of murder in the UK law. So murder is the unlawful killing of a human being with malice aforethought. This is common law definition of murder. The law defines the acts that may lead to an arrest, prosecution, and imprisonment. For an individual to have committed the offence of murder, there must be both the actus reus, as mentioned in the video, and the mental element of intention to kill or cause GBH, which is grievous bodily harm, which is the mens rea. So the actus rea. To convict a defendant of murder, the following must be proved. The victim must have been a person in being. This excludes baby in the womb. The victim must have died. A person is legally dead for the purpose of murder once their brainstem is dead. The victim's death must have been caused by the act or omission of the defendant, and it must also be shown that the killing was unlawful. Person, the victim of homicide must be a person according to law. An unborn child cannot be a victim of murder, manslaughter, because they are not yet people, as in the case of Vaux and France 2006. Unlawfully, if the defendant is able to rely on the defence of self-defence, he or she has not killed unlawfully, as in the case of R and Beckford 1988. Then we go on to looking at the mens rea. So it must be proved beyond reasonable doubt that the defendant has the intention, malice aforethought, to kill to cause GBH, which is grievously bodily harm. If an intention to cause GBH can be proved, this will be sufficient to prove the mental element of the offence. This means sometimes someone may be convicted of murder if their victim dies as a result of the defendant's unlawful actions, even if they only intended to cause the person serious harm. And the case we'll look at in regards to, which was mentioned in the video, was the case of, in regards to mens rea, was the case of Aaron Cunningham, 1982, where the defendant attacked the victim in a pub, believing wrongly that the victim had sexual relations with his fiancée. It was held that the House of Lords declined the opportunity to use the 1966 practice statement. The mens rea of murder remains intention to kill or intention to cause GBH. So causation in criminal liability. Causation refers to the inquiry as to whether the defendant's conduct or omission caused the harm or damage. Causation must be established in all result claims. Causation in criminal liability is divided into factual causation and legal causation. Now we'll look at each one. Factual causation is requires proof that the defendant's conduct was a necessary condition of the consequence. Factual causation is established by applying the but-for test. This asks, but for the actions of the defendant, would the result have occurred? If yes, the result would have occurred in any event. The defendant is not liable. If no, the defendant is liable, as it can be said that their action was a factual cause of the result. And this was identified in the case of Aaron White, 1910. In this case, the defendant put some poison in his mother's milk with the intention of killing her. The mother took a few sips and went to sleep and never woke up. Medical reports revealed that she died from a heart attack and not from the poison. The defendant was not liable for her murder, as his act of poisoning the milk was not the cause of the death. He was liable for attempt. This case established the but-for test. Would the result have been occurred but for the actions of the defendant? If yes, the defendant is not liable, as in the Aaron White case. Legal causation. So legal causation requires proof that the defendant's conduct was sufficiently connected to its occurrence. In simple terms, legal causation requires that the harm must result from a culpable act, as in the case of Aaron Dalloway in 1847. In this case, the defendant was driving a horse and cart down a road without holding onto the reins. A child ran in front of the car and was killed. The defendant was not liable, as he would not have been able to stop the car in time, even if he had been holding the reins. This case is an authority case for the point that the result must be caused by a culpable act. Here, the culpable act was not holding the reins, which was not the cause of death. The defendant was charged with gross negligence manslaughter for his involvement in an incident involving a train being derailed. The defendant was a foreman of some works and carried out on the track. It was held that the defendant's conviction was upheld. The defendant's action need not to be the only cause. Liability can raise provided the defendant's act was more than a minimal cause. However, this does not apply where the offence is one of strict liability, as in the case of Aaron Williams, 2011. In this case, the appellant was driving on a dual carriageway when a man stepped into the road right in front of him. He was unable to stop and the man was killed. The appellant was not speeding and had not in any way been driving recklessly or without care. 2 witnesses gave evidence that it would have been impossible to avoid hitting the man, given the closeness to the car when he stepped out. However, at the time of the incident, the appellant had no driving licence or insurance. He was convicted of causing death by driving without a licence under Section 3ZB of the Road Traffic Act 1988. He appealed on 2 grounds. Firstly, he appealed that the offence could not be committed without proof of fault in causing the death. Secondly, his failure to have a licence and insurance was at fault, but it wasn't this that caused the death. And number 2, alternatively, his driving, although a cause of death, was minimal in relation to the victim's own action in causing death. It was held in this case that the appeal was dismissed, his conviction was upheld, and the offence was one of strict liability, and therefore fault in causing death was not required. It was sufficient that his driving was a cause of death. It need not be a substantial cause. Legal causation continued. So the defendant's action need not be the sole cause of the resulting harm, but it must be more than minimal. In the case of the leading case for this is Binge. There must be no novice actus intervenius. The act of the third party will generally break the chain of causation unless the action was foreseeable, as in the leading case of Pageant 1983. And I'll give you a little bit of facts of these cases. I'm going to go through a little bit of cases all the time, so the rest of the cases please research in your own time. So Pageant is the appellant, aged 31, had separated from his wife and formed a relationship with a 16-year-old girl. She became pregnant. She finished the relationship when she was 6 months pregnant because he was violent towards her. He did not take the break up well and drove to a parent's house armed with a shotgun. He shot the father in the leg and took the mother at gunpoint and demanded she took him to where her daughter was. When thereafter various threatening and violence behaviour, he then took the girl. He drove off with the mother and daughter. The police caught up with him and he kicked the mother out of the car and drove off with the daughter. He took her to a flat and kept her hostage. Armed police followed him. He used the girl as a shield as he came out of the flat, walked along the balcony. The police saw a figure walking towards them but could not see who it was. The appellant fired shots at the police and the police returned fire. The police shot the girl who died. The appellant was convicted of possession of a firearm with intent to endanger life, kidnap of the mother and daughter, attempted murder of the father and 2 police officers, and the manslaughter of the girl. He appealed against the manslaughter conviction on the issue of causation. It was held that the conviction was upheld. The firing at the police officers caused them to fire back. In firing back, the police officers were acting self-defense. His using the girl as a shield caused her death. Where the act is of the victim, the chain of causation will not be broken unless the victim's actions are disproportionate or unreasonable in the circumstances. And that was the case in 1971 in Roberts. In this case, a woman aged 21 accepted a lift from a defendant at a party to take her to another party. She had not met the man before and it was 3 a.m. in the morning. The defendant drove in a different direction to where he told her he was taking her and then stopped in a remote place and started making sexual advances towards her. She refused his advances and he drove off at speed. He then started making further advances whilst driving, and she jumped out of the moving car to escape him. She suffered from concussion and cuts and bruises. The defendant was convicted of actual bodily harm under Section 47 of the Offences Against the Person Act 1861. He appealed, contending that he did not intend or foresee a risk of suffering actual bodily harm from his actions, and he did not foresee the possibility of her jumping out of the car, and therefore her actions amounted to a novice actus reus intervenience. It was held that there is no need to establish an intention or recklessness as to the level of force under Section 47. It is sufficient to establish that the defendant had the intention or reckless as to the assault or battery, where the victim's action were a natural result of the defendant's actions. It matters not whether the defendant could foresee the result, only where the victim's actions were so daft or unexpected that there are no reasonable man could have expected it would be a break in the chain of causation. So legal causation continued. So where medical intervention contributes to death, the courts have been inconsistent to their approach, as in the case of R and Cheshire. In this case, the defendant shot a man in the stomach and thigh. The man was taken to the hospital, where he was operated on and developed breathing difficulties. The hospital gave him a tracheotomy, which is a tube inserted into a windpipe connected to a ventilator. Several weeks after, his wounds were healing and they were no longer life-threatening. However, he continued to have breathing difficulty and died from complications arising from the tracheotomy. The defendant was convicted of murder and appeal. It was held that his conviction was upheld despite the fact that the wounds were not the operative cause of death. Intervening medical treatment could only be regarded as excluding the responsibility of the defendant if it was independent of the defendant's act and so potent in causing the death that the jury regarded the defendant's acts as insignificant. Since the defendant has shot the victim, this could not be regarded as insignificant. The thin skull rule, which also referred to eggshell skull rule. Under this rule, the defendant must take his victim as he finds him. This means that if he has a particularly vulnerable victim, he is fully liable for the consequences to them, even if an ordinary person would not have suffered such a severe consequences. The rule applies irrespective of whether the defendant was aware of the condition, as in the case of R and Haywood, 1908. In this case, the defendant chased his wife out of the house, shouted threats at her. She collapsed and died. He did not physically touch her. She was suffering from a rare thyroid condition, which could lead to death, where physical exertion was accompanied by fright and panic. Both the defendant and his wife were unaware she had this condition. It was held that the defendant was liable for constructive manslaughter, as his unlawful act, which was the assault, caused death. The eggshell thin skull rule applied here. He was therefore fully liable despite the fact an ordinary person of reasonable fortitude would not have died in such circumstances. Intention to murder. Intention requires the highest degree of fault of all levels of mens rea. Direct intent can be said to exist where the defendant embarks on a course of conduct to bring about a result which in fact occurs. Oblique intent can be said to exist where the defendant embarks on a course of conduct to bring about a desired result. A subjective test is concerned with whether the defendant did foresee and the degree of probability of the result occurring from his actions. And this was the case of R and Nedrick, 1986. In this case, the defendant Nedrick held a grudge against a woman. In the middle of the night, he drove to her house before pouring petrol through her letterbox and igniting it. The defendant, without warning anyone in the house, then drove home. As a result of the fire, a child died and Nedrick was charged with murder. The trial judge directed the jury that if the defendant knew it was highly probable that the act would result in a serious bodily harm to someone, even if it did not desire that result, he would be guilty of murder. Nedrick was convicted of murder and appealed, and the issue in this case was whether a jury is entitled to infer intent if they consider defendant's actions highly likely to cause death or serious bodily harm. Whether the defendant's foresight of the likely consequences of his act is sufficient to satisfy the mens rea of murder as intent, whether the trial judge's direction to the jury that the defendant could be guilty of murder if he knew he was highly probable that serious bodily harm could well occur as a result of his act was misdirection. In this case, the decision was that the appeal was upheld. The trial judge's direction was a misdirection, modifying the case of R and Maloney 1985, where the Court of Appeal held that the jury should be directed that they are not entitled to infer intention unless they are satisfied that they felt sure that death or serious bodily injury was a virtual certainty of the defendant's action, and the defendant knew this. Mandatory life sentence and issues. The mandatory life sentence for murder is life imprisonment. The Murder Abolition of the Death Penalty Act 1965, Section 1, subsection 1. However, numerous judgments have suggested that sentence should be more open to judicial discretion, as in the case of R and Ho 1987. In this case, Ho and Bailey, both aged 19, and Bannister, aged 20, were acting under orders of Murray, aged 35. The charges related to 2 murders and 1 conspiracy to murder. The first murder related to a 17-year-old male victim, Elga. Murray had driven them to a public lavatory. Elga was naked and sobbing and was subjected to torture and compelled to undergo sexual perversions. Ho and Bannister took part in kicking and punching Elga and were told they would succumb to similar treatment if they did not do so, as Murray ordered. Bailey strangled Elga, resulting in his death. The second killing took place the following night at the same location on 19-year-old male Pollitt. Murray had ordered Ho and Bannister to strangle him, and they compiled. The third charge related to a similar incident. However, the intended victim managed to escape. It was held in this case that the defence of duress is not available for murder, whether it be principal in the first or second degree, and DPP for Northern Ireland and Lynched overruled in this case. The obiter dicta was the defence should not be available to one who attempts to kill. Lord Griffin's identified in this case that we face a rising tide of violence and terrorism against which the law must stand firm, recognising that its high duty is to protect the freedom and lives of those that live under it. The sanctity of human life lies at the root of this ideal, and I would do nothing to undermine it, be it ever so slight. Attempted murder requires proof of an intent to kill, whereas in murder it is sufficient to prove an intent to cause serious injury. It cannot be right to allow the defence to one who may be more intent upon taking a life than the murderer. So 2.2, we need to look at illustrated circumstances giving rise to voluntary and involuntary manslaughter. So the voluntary manslaughter, the requirement of the defence of provocation under Section 3 of the Homicide Act is there must be evidence of provocation, as in the case of R and Davies, 1975. In this case, the defendant killed his wife after seeing her lover walk towards her place of work. It was held that the act of the lover walking to her workplace could amount to provocative act, and the issue of provocation should have been put before the jury. The provocative act need not be deliberately aimed at provoking the victim, nor must the provocation come from the victim. The next one is the defendant must have provoked to lose their self-control, as in the case of Duffy and R against Duffy 1949. Where the appellant attacked and killed her husband with a hammer and hatchet whilst he was sleeping. He had subjected her to violence throughout the marriage. And then thirdly, the provocation must be such as to make a reasonable man do as the defendant did, as in the case of DPP and Bedder. This third element of the defence of provocation is question of the jury. In the case of R and Beda, the appellant killed a prostitute. He was sexually impotent according to his evidence. He had tried to have sexual intercourse with her and failed. She taunted him with his failure and tried to get away from his grasp. In the course of her attempts to do so, she slapped him in the face, punched him in the stomach and kicked him in the groin, whereupon he took a knife out of his pocket and stabbed her twice and caused her death. At his trial for murder, he raised the defense provocation. The jury convicted him of murder. The defendant appealed, contending that in assessing whether a reasonable man would have provoked him to act as the defendant did, the jury considered the effect of an impotent man. It was held that the appeal was dismissed. The test was held to be entirely subjective. No account could be taken of the particular characteristics of the defendant. And this law is no longer represented as good law in the UK law. Provocation. The Coroners and Justice Act 2009 abolished the defence of provocation and replaced it with a new defence of self-control. Some of the main changes that came about were that, firstly, that there is no requirement the loss of self-control need be sudden. Section 54, subsection 2. Sexual infidelity will not count as qualifying trigger. Qualifying trigger must relate to either fear of violence from the deceased or things done or said. There are two requirements to be satisfied where the trigger is through things done or said. These are: the circumstances must be of an extremely grave character, and the circumstances must have caused the defendant to have a justifiable sense of being wronged. If the fear of violence or things done or said were incited by the defendant, they are to be disregarded. So diminished responsibility. Diminished responsibility is set out in Section 2 of the Homicide Act 1957, as amended by Section 52 of the Coroners and Justice Act 2009. Where the defence of diminished responsibility is successful pleaded, it has the effect of reducing a murder conviction to the manslaughter. The effect is to reduce criminal liability rather than to resolve the defendant from liability completely. Carry on with diminished responsibility. So to rely on the defence, the defendant must be able to demonstrate the following: an abnormality of mental functioning caused by a recognised mental condition, and that was the case in R and Bryan, 1960. In this case, the appellant murdered a young girl staying in a YWCA hostel. He then mutilated her body. He did so as he was suffering from irresistible impulses which he was unable to control. It was held in this that abnormality of mind was wide enough to cover the mind's activities in all aspects, including the ability to exercise willpower, to control physical acts in accordance with rational judgment. But abnormality of mind means a state of mind so different from that of an ordinary human being that a reasonable man would term it abnormal. He was thus allowed the defence to reduce the murder conviction to manslaughter in this case. Which provides an explanation for the defendant's acts or omissions in being party to the killings. The leading cases are and Tandy, so please have a look at this in your own time, which substantially impaired his or her mental ability to either understand the nature of their conduct or form a rational judgment or exercise self-control, as in the case of R and Campbell, 1997, which we looked at earlier in regards to the facts of the case. Voluntary manslaughter, loss of self-control. This was introduced by Section 54 of the Coroners and Justice Act 2009. Section 54(1) states a person who kills or was party to a killing may be convicted of manslaughter rather than murder where there exists. So the first one is a loss of self-control, and this was the case of R and Abrahams, 1982. In this case, there were two appellants. who had been harassed and terrorized by John Monk. Ibrahim's girlfriend Andronica left him to start a relationship with Monk. However, Monk was extremely violent towards her, leading her to flee the country. She'd returned to the UK and resumed the relationship with Abrahams. Monk was serving a sentence in Borstal. However, on release, Monk started visiting the couple, using violence and making threats, and forcing Andronica to sleep with him. The police had been informed of the events but did not take action. On one of his visits, Gregory, a friend of the couple, witnessed this violence. They hatched a plan whereby Andronica would invite Monk round, get him drunk and entice him into bed. Ibrahim's and Gregory would then burst in and beat him up. In fact, the two appellants went further than planned and killed Monk. They stated that once they started beating him, they lost their control. The trial judge did not allow the defence of provocation to be put before the jury, as the planning indicated that there was no sudden and temporary loss of self-control, and the defendants appealed this, and the appeal was dismissed. Lord Justice Lawton stated in this case that they carried out the plan. They were masters of their minds when carrying it out, because they worked out the details of the considerable skill, and in pursuing the plan as they did on the Friday night, they were still masters of their own minds. They were doing what they planned to do when they went into Monk's bedroom, and Gregory struck the first blow, then again was pursuant to the plan which had been worked out, and they were masters of their own minds. It follows in our judgment that Mr. Justice McNeill was right in ruling that there was no evidence of loss of self-control. In those circumstances, the appeal will be dismissed. The court in this case wished to say that this case is the most unusual one, and had it not been for the appalling criminal behaviour of the dead man, these two appellants would not today be serving sentences of life imprisonment for murder. It is to be hoped that a copy of this judgment will be sent to the appropriate department of the Home Office, and that the parole board will as soon as possible be alerted to the very unusual and very disturbing facts of this case. So this case was very important in highlighting the issue of loss of self-control, and it was obviously the courts regarded it as quite an important case and referred it to the Home Office, to the parole board. Then we've got the loss of self-control, and it had a qualifying trigger. The case of leading cases are and Hatter 2013, so please have a look in your own time. As I stated, I will not be going through all the cases, just the ones that are relevant to, which I feel that are relevant. The next one, a person of D's sex and age with the normal degree of tolerance and self-restraint, and in the circumstances of D, might have reacted in the same or similar way to D, as in the case of DPP and Camplin, 1978. So constructive manslaughter. Constructive manslaughter is a form of involuntary manslaughter that an unlawful killing has taken place where the defendant lacks the mens rea of murder. Elements of constructive manslaughter, there must be an unlawful act, as is the case of R. and Fenton, 1830. In this case, the defendant threw some stones down a mine shaft. This caused scaffolding to collapse and resulted in the death of some miners. It was held in this case that the tort of trespass was sufficient to constitute an unlawful act for the purposes of constructive manslaughter. This position of law was changed in R. and Franklin, 1883, where it was held that the act must be against criminal law as opposed to civil law to amount to an unlawful act for the purposes of manslaughter. The unlawful act must be dangerous, so as in the leading case of R. and Church, 1965, and the unlawful dangerous act must cause death, as in the case of R. and Cato, 1976. Gross negligence. Gross negligence manslaughter is a form of involuntary manslaughter where the defendant is observatively acting lawful. Gross negligence manslaughter can be said to apply where the defendant commits a lawful act in such a way as to render the actions criminal or committed by omission, as in the case of R. and Seymour, 1983. However, the House of Lords in the case of Adamoko held that the law as stated the case should no longer apply, since the underlying statutory provisions on which it rested have now been repealed by the Road Traffic Act 1991. Leading case Adamoko, 1994. 2.3, we're looking at assessing the nature of non-fatal offences against the person. So non-fatal offences against the person, we have GBH at the top with intent, section 18 of the Offences Against Person Act 1861. Actual AR, which actus reus is wounding of the causing of GBH, and the mens rea is intention plus ulterior intent. Wounding and inflicting GBH, section 20, actus rea, wounding or inflicting GBH, mens rea, intention or recklessness as to some harm. Assaulting occasional body harm, section 47 of the Offences Against Person Act 1861. The mens actus reus here is common assault or battery resulting in ABH, and the mens rea is intention to subjective recklessness to the common assault or battery only. The common assault is actus reus causing apprehension of immediate and unlawful violence, and the mens rea intention to subjective recklessness thereto, and battery, the actus reus, is infliction of force or violence, the merest touching, mens rea intention to subjective reckless thereto. Common assault, the definition is as an assault is committed where the defendant intentionally or recklessly causes the victim to apprehend immediate unlawful personal violence. Actus reus, apprehend, the victim need not be put in fear but must be aware that they are about to be subjected to violence. If the victim does not anticipate unlawful personal violence, there is no assault, as in the case of R and Lamb. In this case, the defendant, Terence Walter Lamb, was arraigned on indictment before Glyn Jones Justice and a jury, charging he lawfully killed Timothy O'Donoghue. Lamb possessed a Smith and Wesson revolver with a 5-chambered cylinder. Lamb was joking with O'Donoghue, his best friend, by pointing the revolver at him, whilst the cylinder contained 2 bullets in the chambers, neither of which were opposite the barrel. O'Donoghue likewise played along with the joke and was not concerned by the situation. Lamb then pulled the trigger, thereby rotating the cylinder clockwise, causing a bullet to be placed opposite the barrel. The bullet was struck by a striking pin and killed O'Donoghue. Lamb contended that he had no intention to harm O'Donoghue or intention to fire the revolver. He claimed that the killing of O'Donoghue was a mistake because he failed to acknowledge that the chamber rotated clockwise when the trigger was pulled, and then he otherwise believed that the 2 bullets in the cylinder were not in the barrel. The prosecution adduced evidence from 3 expert witnesses. The 3 experts were then Mr. McCarthy, a firearms expert, Mr. Burr, an executive officer attached to the firearms branch of Scotland, and police constable Pullen. It was held in this case that the judgment of Lamb, having regard to the judgment of Andrews and Director of Public Prosecutions and Aaron Church, held that because mens rea was an essential element to assault, involuntary manslaughter on the ground of unlawful and dangerous act could not be established on the facts except by proving the element of intention in regards to the technical assault, such that Lamb's conduct was unlawful. Specifically, Lord Justice Sachs, Lyell and Geoffrey Lane stated that it is the correct view that for the act to be unlawful, it must constitute at least a technical assault. Having said that, the judgment also made reference to deficiency in summing up the relating to criminal negligence, such as omission of reference to the expert. Where the victim apprehends immediate lawful personal violence, an assault will be committed even if there was no actual threat of violence, as in the case of Logden and DPP 1976. Common assault. So apprehend, the actions of the defendant must cause the victim to apprehend immediate unlawful personal violence. Originally, it was thought that only conduct would amount to an assault, as in the case of R and Constanza 1997. Words can also negate as an assault, as in the case of Tuberville Savage 1689. Immediate threats or future violence will not amount to an assault. However, the courts have adopted a more liberal approach to the requirement of immediacy, as in the case of Smith and Constable. Words can also negate an assault, as in the case of Tuberville and Savage 1669. Immediate threats of future violence will not amount to an assault. However, the courts have adopted a more liberal approach to the requirement of immediacy, as in Smith and Chief Constable of Working. Common assault. Unlawful. If the defendant has a lawful excuse to use force, the actions will not amount to an assault. This includes reasonable punishment of a child, Section 58 of the Children Act 2004, where the victim consents and where the defendant acts in self-defense or prevention of a crime. Personal violence. The term personal violence can be misleading in that the victim need only apprehend a level of force that amounts to a technical battery. For example, any touching will suffice. Common assault, mens rea. The mens rea of assault is intention. Common assault is the mens rea of assault. The mens rea of assault is the intention to cause the victim to apprehend immediate unlawful personal violence or being reckless to whether such apprehension is caused, in the case of MPC and Fagan, 1969. The case of R and Parliamentary established that subjective recklessness applies to non-fatal offences against the person, as in R and Parliamentary, 1991. Battery. The definition of battery is unlawful application of force by the defendant upon the victim. Actus reus of battery application. The application of force need not be direct, as in the leading case of DPP and K, which was a minor, 1990. Unlawful. If the defendant has a lawful excuse to use force, the actions will not amount to a battery. This includes reasonable punishment of a child, Section 58, Children Act 2004, where the defendant acts in self-defense or prevention of the act, where the victim consents, as in the case of Collins and Wilcock, 1984. Actus rea of battery, physical force, or an intentional or reckless touching of another person without the consent of the person and without lawful excuse. It not need necessarily be hostile, rude, or aggressive, as in the case of DPP and K, 1990. The mens rea of battery, intention to apply unlawful physical force or being reckless as to whether such force is applied. ABH, which is actually bodily harm, and the definition is an offence to commit an assault occasioning actual bodily harm. Actus rea of ABH is assault or battery. To constitute an offence under Section 47, all the elements of assault or battery must be present, as in the case of AG reference number 6 of 1981. Actual bodily harm. Actually bodily harm includes any hurt or injury calculated to interfere with the health or comfort of the victim, as in the case of R and Chan Fook, 1994, which you can have a look at in your own time. The mens rea of ABH is the mens rea of ABH's intention to or reckless subjective as to the assault or battery. There is no requirement that the defendant intended or was reckless as to the injury inflicted, as in R and Roberts, 1971. Grievous bodily harm. Under Section 20, Offences Against the Person, Act 1861, the definition of this is whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm on any person, either with or without a weapon or instrument, shall be guilty of misdemeanor. The actus rea for GBH is unlawfully. Lawful GBH covers those who are acting in self-defense or prevention of crime in limited circumstances, where the victim has consented, for example, surgical interferences, and where the injury results from properly conducted games and sports, such as in the case of R and Hopley, 1860. Grievous bodily harm. The actus reus is wound. A wound exists where there is a break in the continuity of the skin, as in the case of Marathi and Brooks, 1834. Grievous bodily harm means really serious harm, as in DPP and Smith 1961, which we explained earlier. If the victim is particularly vulnerable, the jury is entitled to take this into account when assessing if the injury is really serious, which is the case of R and Bollum 2004. GBH, actus reus of GBH. Continued, the question of what amounts to really serious harm is to be objectively assessed, as in the case of R and Brown and Stratton 1997. GBH includes psychiatric injury, as in the leading case of R and Burstone 1997, and it was held to include indirect application of force, as in the case of R and Martin 1881. Actus reus of GBH, inflict. Originally, the courts interpreted inflict to mean that there must be proof of assault or battery, as in the case of R and Clarence, 1889. More recently, inflict was interpreted to mean the direct or indirect application of force, as in the case of R and Wilson, 1984. In the context of psychiatric injury, the word inflict simply means cause. There's no requirement of assault or battery or direct or indirect application of force, as in R and Burstone, 1997. Mens rea of GBH, the defendant must have the intention or be reckless as to the cause of the harm. There's no need for the prosecution to establish that they intended or was reckless as to causing serious harm, as in the case of R and Savage, 1991. Grievous bodily harm under Section 18, Offences Against the Person Act, 1861, which we mentioned this earlier, whosoever shall unlawfully, maliciously, by any means whatsoever, wound or cause any grievous bodily harm to any person with intent to do some grievously bodily harm to any person, or with the intent to resist, to prevent the lawful apprehension or detainer of any person, shall be guilty of felony. Actus rea of GBH, unlawfully wound or cause GBH on any person. Mens rea, intention to cause GBH or intention to resist or prevent the lawful detainer of that person. Protection from Harassment Act 1997. Section 1 of the 1997 Act states that a person must not pursue a course of conduct which amounts to harassment of another, and which he knows or ought to know amounts to such harassment. A victim would not need to pursue both civil and criminal remedies. They might decide to pursue a civil remedies where there was not enough evidence for a criminal prosecution, but perhaps enough to obtain a civil order. In criminal cases, the matter must be proved beyond reasonable doubt. Protection from the Harassment Act 1997. Defences, so where harassment has been proved, the defendant would have to show one of the following. Firstly, that the conduct was for the purposes of preventing or detecting crime. Secondly, it was pursued under an enactment of rule of law, or in particular circumstance, the conduct was unreasonable. That's all for today. We've looked at quite a lot with reference to a lot of cases in regards to looking at the issue of actus rea, murder, manslaughter, DBH, and actual bodily harm with reference to case law. Please look at the cases that we didn't go through. Most of the cases we went through, but some of the other ones, please have a look for your next session. And thank you for attending today's class, and see you in the next class, which will be Learning Outcome 3. Please go on to Moodle to get any sort of additional reading to help you with the assignment area. Thank you for your patience, and thank you for attending today's session. Thank you.